catch him. And he says, what did I do wrong? I followed my contract. Cannot, no? So you may have a contract, but the law still will catch you. Okay. Then might bring you to the question about, so we now see that section 20 says if you want to terminate, you need to have just cause or excuse. So we've just looked at it. Hang on a minute, doesn't this contradict the contract clause? It does. Next slide, please. So how can we reconcile section 20 with this clause? Why do we even bother to have the clause? Maybe we just took out the clause, or we say only the employee can terminate by serving notice or paying salary. Forget about either party. Okay, how do we reconcile this? Slightly technical. So follow me on this one, yeah? For an employee who has been dismissed, to file a complaint under section 20 of the Industrial Relations Act, there is a very strict timeline. And that timeline is 60 days. An employee who wants to file a complaint under section 20 must do so within 60 days of his dismissal. So if it's within 60 days, he can file a complaint with the IR department. If it's more than 60 days and he attempts to file a complaint, the complaint should not be accepted, and even if it was accepted, it can be challenged in court later. Alright. So what's the difference? What happens if someone didn't know about this law, and after 4 or 5 months, a friend of the employee says, hey, you've been dismissed unfairly, go file your complaint. But when they try to file a complaint, IR will say, sorry, my friend, 60 days have elapsed, I can't accept your complaint. They then decide, okay, I will sue the employer in the normal civil courts, your magistrate's court or your sessions court or your high court. What is the difference? The difference is this. If an employee files a complaint within 60 days with the IR department and it ends up going to the industrial court, and let's say at the industrial court, I am the employer, I come to court and I say, my lord, what did I do wrong? I terminated my employee's contract based on this clause in the contract which he himself agreed and signed off. I gave him notice and terminated. Nothing wrong. You know what the industrial court will say? I'm sorry, Mr. Employer. We are a special court. In this court, that clause does not apply. We cannot allow you to terminate without reason in this court. Yeah? But if someone doesn't file within 60 days and he sues in the normal civil court, and we go to the magistrate's court or sessions court or high court, and I go as the employer and I say, my lord, what did I do wrong? I terminated based on the contract. You know what the normal court will say? That's fine. So the normal court accepts the clause. The industrial court doesn't. That is why when you dismiss an employee, what you should do is cross your fingers, your toes and your ears and whatever for 60 days and hope they don't file. Because if they don't file, you're safe. But if they file, game on. We have to be careful. Yeah? So that's how you reconcile. There is still value in having the clause either party because it is valid in the normal course. But if someone files within 60 days, you can't just go to court and say, well, I followed this clause and therefore the dismissal is fair. The court will say, I need to see just cause or excuse. Right? So, if that is the case, and you now have seen that Section 20 applies to every employee, this now means, as an employer, if you want to dismiss an employee, you need to have proper reason. It's not, I'm not saying that you cannot dismiss. You can dismiss an employee. By all means, you have many reasons why you can dismiss an employee. But what happens is, we need to follow a very proper process. Right? So if I were to ask some of you guys here, okay, can you tell me on what reasons would you want to terminate the services of an employee? On what grounds? Sorry? Breach of trust. She says so, employee does something which is, as a result of which I cannot trust the employee because they've, let's say, taken a bribe or stolen something. So you're looking at terminating for misconduct. What other reasons would you want to terminate? Non-performance. Someone is not performing, so we terminate due to non-performance. It might be an unfortunate situation where an employee has contracted a very serious illness or met with an accident as a result of which they cannot perform their duties anymore, so you may want to terminate on grounds of medical reasons. You may want to retrench employees because business is bad, you're downsizing, or maybe not. It doesn't have to be a negative. Maybe you've outsourced a particular function and therefore you don't need the need for employees. So there are various reasons for which an employee's services can be terminated. And here's the challenge. For each type of termination, the process is different. The process that you have to manage is different. Can you go back? Now, what we need to understand is the wordings in the law are where a workman considers. To me, that is the reason why when Roy shared with you the number of cases, right? Because the word is considers. For an employee to want to complain under Section 20, all that is required is for that employee to feel that the dismissal was unfair, and that is enough, he can file. The IR department does not vet. They do not say, wait, hang on, before I accept your complaint, let me be satisfied that your complaint deserves to be recorded by me. They don't do that. If the employee feels the dismissal is unfair, he can file. Which means, even the most reasonable and proper dismissal, but the employee who has been dismissed feels that the dismissal is unfair, he can file. Right? So let me just give you a wild example. Let's say we're having the company has a town hall session, so MD is going to speak, 100 employees are there. Amongst the 100 employees, Mr. A and Mr. B start to have a fight. Mr. A takes out a knife and stabs and kills Mr. B. 98 witnesses to the murder. Clearly the employer will dismiss Mr. A, right? Mr. A can file his complaint if he wants to. You see, you must understand, filing a complaint is but one step. Whether he wins the case or another, that's a different story. Filing a complaint is like buying a lottery ticket. Any one of us can buy a lottery ticket, correct? But whether you win the first prize or not, different story. So whether you win in court, that's a different story. Yeah? So, if you go to the next. Keep going like this. Okay. Let me just share with you what happens when an employee files a complaint. Okay, when an employee files a complaint, the employee complains to the IR department. And for those of you who may want to find out for your personal reasons where are the which IR department to go to, the law says you have to file in the IR department closest to your workplace. So if you are dismissed in KL, don't file in Penang. You have to file in here, right? So once you're dismissed, the matter doesn't go straight to court. What happens is the IR department will call both parties to try and settle the matter. How do they try and settle the matter? Basically, they try to persuade both parties. Maybe they tell the employer, why don't you pay a bit of compensation, 6 months, and then I'll ask the employee to withdraw his case. They tell the employee, you better settle, your case is very weak. They play this mediation role, try and get parties to settle. No lawyers are allowed at that meeting, it's provided in the law. Lawyers are not allowed to be involved in the conciliation meeting. You know why? Because if lawyers were involved, there will be no settlement. Right? Clearly, it's in the lawyer's interest for there not to be a settlement, because if there was a settlement, work done is very small, fees will be very small. Right? So the law says no lawyers. So normally, companies will represent themselves. The Malaysian Employees Federation can go for that meeting on behalf of the company. For the employee, again, they normally represent themselves, but if it's a unionized company, they can be represented by someone from MTUC, Malaysian Trade Union Congress. So if they try to settle, and if the IR department is successful in settling the matter is closed. Matter ends there. But sometimes the matter cannot be settled, because maybe, number one, the employer, from a principal standpoint, he says, well, this guy stole something from me, I am not willing to pay him 1 cent in compensation, so I don't want to settle. Or maybe the employee is having ridiculously high demands. I want 24 months, otherwise I will not settle. He wants 24 months salary, so cannot settle. So if the matter cannot be settled, what happens? It then falls with the Minister of Human Resource. Only the Minister of Human Resource, and even he does not have the power to decide who is right, who is wrong. The minister only has the power to decide, should I refer this matter to court or don't refer? That is all his powers are. Now, if I were to ask you guys, how do you think a minister will make that decision? Considering he was not involved in the settlement discussion, so he never saw the employer, he never saw the employee, he never heard from them. But yet he decides, should I refer or not? How do you think he decides? Based on what? Report from the officer. The officer's report will be based on the documents that you have submitted. As the employer, you will go and submit to the IR office, these are the reasons why I dismissed him. He stole the projector, I issued him a show cause letter, this was his reply was not accepted, we issued him a notice of inquiry, we conducted a domestic inquiry, these are the minutes of the domestic inquiry, we found him guilty, and therefore it's theft, clearly, I've got to let him go. So the minister's decision is based entirely on your documents. Because he doesn't listen to you, he doesn't listen to the employee, he goes on your documents. Right, so now the minister will decide, refer or don't refer. Now, if the minister decides don't refer because he's satisfied, he looks at all the documents and thinks, well, I think the company's done everything right here, let me not waste the time of the industrial court, I don't refer. If he doesn't refer, what happens? The employee is unsatisfied, right? Now,